Good afternoon and welcome back. Ms. Perec, Mr. Boyle. Can I just clarify that this afternoon we've got Mr. Brown for the appellants and Mr. Magnuson for the council? Welcome to you both.
Yes, correct. Thank you, Mark.
I'm conscious that this session is at my behest. I recognise that the details are somewhat fluid in relation to particular sites, but we work on the best available evidence that we have. And part of the issue will be the nub of when you consider, whether you consider the sites as of March 2020 or as of now. But obviously we'll need to have that in our minds when we talk about it. This afternoon I want to cover four key points. One is just views on the definition of deliverable, and that's in respect of the framework definition in the glossary. I'm going to ask the council just to summarise the points on its sites in referred to in table A2, and that's probably best taken from the rebuttal proof. And then just some clarity on numbers for the Hounsome site, where some of the evidence didn't quite add up numerically, so I've got a couple of questions on that. I recognise that as things stand at the moment, there's marginally more than half a year's supply difference between the two parties. 0.63 is the difference. And I'm conscious that this morning Mr. Miller said that the position at 4.83 year supply was a modest shortfall. So in that context, obviously I have to take a view taking all the evidence into account, and in either scenario there still remains a shortfall. That's, I think, an agreed position between the parties. So just in terms of me, the importance of me being able to understand the detail and the discrepancies between the two different positions, really that's where I wanted to go to with the roundtable session this afternoon. So if there are any questions before I move on to just a discussion on the definition of deliverable. Are there any questions from anybody? No? Okay. Just turning to the framework definition, I'm going to part B in terms of where a site has outline planning permission. It should only be considered deliverable where there's clear evidence that housing completions will begin on site within 5 years. And I fully understand that issue is a matter of confidence in relation to the particular sites. So that's really why I wanted to just look at the sites listed at table A2, in particular sites 2 to 10, and just have a brief discussion on those. But have either of you got any comments on the definition of deliverable in the way I've outlined that?
Not from me, madam.
Mr. Brown, your hand's raised.
Hi, Ma'am. Good afternoon. No, you set that out rather helpfully. Just to say that you'll have picked up where I've dealt with it in my proof. And there's also the reference to deliverability in ID 68007 of the PPG. I in turn referenced a couple of appeal decisions. I'm not going to take you there, you'll have seen them, but I would just like to flag up the approach set out in CD 5.12, Ma'am, and that's the Sonning Common decision. And I won't read them out, but it's for your note, paragraphs 20 to 22, which set out the requirement for cogent evidence. So they're important points. So I think that that will do from me for now on that point. Thank you.
Okay. Well, then perhaps I can just ask the council just to work through the summary of the sites as set out in the rebuttal. Just start in the right place.
Yes. So from 2.0 of my rebuttal statement onwards, at 2.1 you'll see table 1 the respective supply positions. So the disputed, we've got one large site commitment that's disputed, and the difference in numbers is 105 dwellings. And then the remainder, if you like, of the disputed sites are local plan and neighbourhood plan site allocations. And the total difference in our respective positions on those is 463. So the council maintains that it has a supply position of 4,450 dwellings in the 5-year period. And in terms of the disputed sites, and I think you alluded to the local plan and neighbourhood plan allocations in the first instance, and you can see it paragraph 2.8 of my rebuttal statement that we start there with Swing Swan Lane. So essentially that what you've got there is an assessment of the council's position as reported in the AMR, and what we've also provided for information purposes is an up-to-date position or anything that's happened subsequent to the publication of the AMR that we think would be useful to bring to your attention, madam.
So in terms of that particular site, obviously reserve matters are submitted and well, actually appear to have been before the council for some months now. Is that's still the same position?
Yeah, this one is an allocated site with outline planning consent, and it has a reserve matters application, and that yes, the reserve matters is currently under consideration, as I understand it, madam.
And the prospect of the conclusion of that is what?
My understanding from the council's perspective is that it's a priority site for the landowner, and they have every confidence that it will be delivered within the 5-year period.
But there's no indication of what's causing the issue with that.
I'm
just going to the point about whether there is confidence, those sites will proceed, and what I'm not clear about is essentially what the hold-up is with that. Why is it not progressing, and what is the confidence that it will come forward?
Yeah, I would need to check with the council on the specifics of that particular site, madam.
So there's no update from what you've given?
No update beyond what's in the written evidence.
And the second site at the Hollies, for the 21?
Yeah, again, this site's gained outline permission for 21 apartments. Homes England has stated that the site is deliverable and is being actively marketed for a developer partner. And they have actually confirmed to the council that they forecast 21 units to be completed in 22-23 and anticipating reserve matters planning in spring/summer 2021. With a start on site expected late 2021. The council have engaged through the forthcoming 2021 AMR process, and will update the site delivery if required, the trajectory. But as far as the council are concerned, that they have every confidence that site will come forward in the 5-year period.
I'm conscious that Homes England's forecast of 21 units with reserve matters by the spring/summer. We're sort of past that date now, so that's been and gone really. We're into the autumn of 2021 now, so that doesn't appear to have materialised.
No, that's the only update I have for you is in the written evidence, madam. Again, I'll have to lean on my officers of the council for any further information.
Are there any other contributions from your colleagues who are with us at the moment or not? I don't see. Mr. Brown, your hand's up.
Yes, ma'am. I just wanted a procedure point. I appreciate this is a forum for you to get the information you need, and I just wondered if you wanted me to respond on all of these sites, if you're going to allow the council to set out their position, and it's only if you wanted my comments on their responses. I didn't know if you're going to go site by site and allow me an opportunity to respond, or how you want to play it. In your hands.
I'm more than happy for you to for us to do that as we go through. I just really wanted to just challenge some of the information that that I'd been given, particularly given that the dates had passed, so that I could work out, what the likelihood of that confidence that's sought by the definition of deliverable, and where that clear evidence is, and whether we should or shouldn't include them. So I'm more than content if you've got comments on either of the first two sites for you to contribute as we go through.
Super. Well, thank you.
This is a round table rather than a specifically one side and then the other.
Well, super. In that case, I do have a tendency to interject. So if that's okay, if the council respond on each site and then I respond straight away. So just take the opportunity on Hounslow Fields, which was referenced earlier on, Mr. Magnuson referencing the council's assumptions there. I think the answer on evidence, ma'am, is my document SB1. That is the only evidence you need on that site, by and large, which the council assumes 490 dwellings for that site, and the developer's own trajectory for Hounslow Fields now confirms 385. So straight away, as per table A2 in the Housing Land Supply Statement of Common Ground, 105 dwellings falls off the council's supply figure. There's no rebuttal to that in Mr. Magnuson's response. So that is the figure one adopts for the purpose of that site. That is the evidence put forward on it.
I was going to come to Hounslow Fields towards the end, because that's the order in which they appeared in the rebuttal statement. But since you mentioned that now, the query that I had in relation to that was the figures that I've been given appear to relate to 600 dwellings in the reserve matters applications. That's 94 on one site, and then 143 and 363 dwellings as set out at the top of page 11 of the rebuttal statement, which to my mind adds up to more than 490.
I think, ma'am, if I may, and Mr. Magnuson, kick me if I'm wrong on any of this, but in terms of the trajectory for that site, the figures are set out in appendix. It's one of the appendices to the AMR. The AMR is CD 3.11, and that's the 2020 AMR. And at the back of that, there's the schedule of sites. And whilst it might have permission for more, the assumption by the council in table A2 is that it will achieve 490 in the current 5-year period, with the build out rates extending thereafter beyond the 5-year period. So they're not relying upon all of the dwellings that have got RM or outline to come forward in the 5-year period. And Vistra's own trajectory now is saying 385, not the 490 that was assumed at the time, ma'am.
And does that concur with your position, Mr. Magnuson?
Yes, my understanding is that there are dwellings to come be delivered beyond the 5-year horizon, the trajectory.
Okay, so those would arise out of the current reserve matters applications and the length of time it would take to build those sites out. Okay, thank you. Just going. So anything more on the polys before I move on to Evanger Road, Whitchurch?
Swing Swang Lane was touched upon, and I'm in, as I've set out in my evidence on page 27, the site is not and was not deliverable at the base date. The reserve matters application was not validated until after the base date. Redder advancing on that. There's no clear, cogent evidence on which one can rely to say it's deliverable, and hence why my proof, ma'am, I've taken that out entirely. So no dwellings on that site because of the lack of evidence that it's deliverable at the base date.
Mr. Magnuson?
I've got nothing to add on that. I mean, as will be the case with all of the sites that are under consideration this afternoon, it's going to be for the decision maker, in this case, the planning inspector, to make a call on whether the evidence as presented in our rebuttal is sufficient to demonstrate deliverability. All I can say is that in terms of when the council officer produced the AMR, April 2020, it was considered by the officers that those sites did meet with the definition of deliverable for the reasons identified in the AMR. And as I alluded to earlier, we've included some subsequent information just for your benefit, but I haven't got anything else specifically to say on that particular site. No.
Okay. Thank you. So just the position on Evinger Road, Whitchurch then?
Mum, could I just take the opportunity to come back on the Hollies?
Yep, sorry.
Is that okay?
That's fine.
Thank you. On the Hollies, paragraph 2.16 of Mr. Magnuson's rebuttal suggests that dialogue with Homes England represents clear evidence. Well, of course, it does not. It needs a lot more than that, but they're not going to build the houses. There's no developer on board, and it clearly fails demonstrably to meet that test of clear evidence. Discussion is not evidence, Mum. So that there is no evidence that that site's deliverable.
Mr. Magnuson?
Yeah, absolutely. Again, I'm relaying information from the council officers. In their mind, haven't been privy to those conversations. I'm a consultant. I haven't been privy to the conversations I have with Homes England, but obviously they've got a degree of confidence that that site will come forward in the planned period. Sorry, in the 5-year period.
Okay, moving to Evinger Road. Any comments on that? It says obviously there's reserve matters.
Yeah, that's now been, as I understand it, that's now been received by the council and prior to their deadline for submission of the 21st of June 2021. And that's an indication that the developers are well aware of the actions they need to take in terms of bringing forward that site and to ensure the successful implementation of the various consents. So yeah, again, with the submission of the reserve matters, the council are confident that that site will come forward in a 5-year period. Again, just to add, the councils are obviously looking to produce their next AMR. This is the 2021 AMR process, so they're collating evidence as we speak on that particular document. So obviously, any trajectories that appear within the current 5-year 2020 AMR will be subject to revision and amendment as necessary as part of that process.
Appreciate that. Mr. Brown?
Yeah, I picked up on that point actually, Mum. That just goes to the heart of the discussion about the lack of confidence, because almost at every turn and every site there's reference to it being reviewed through the next AMR. I think that just underlines my analysis that there isn't confidence that these sites are deliverable. This Evinger Road Whitchurch site is another prime candidate for the lack of clear evidence at the Bay State. And Mum, I've cited the Woolpit decision, which is CD 5.9, and simply go to paragraph 3.18 of my proof.
Sorry, can you just give me that reference again, please? CD
5.9, and you'll see that set out at paragraph 3.18 of my proof. So dealing with this site, just going back to my notes. Yes, it had an outline permission at the Bay State, but there was no reserve matters at the Bay State, and that was only validated on the 20th of May. Currently, there's an LLFA objection to the RM. Network Rail have been asking questions about its implementation, and County Highways are seeking amendments. So this site clearly wasn't deliverable as at the Bay State. Again, you cannot just make an assumption about delivery. You need clear evidence, and that evidence was not available at the Bay State, Mum.
Okay. So that brings us to Manydown. I think that's the next one.
Okay, that's
If I missed one.
no, I think that is actually, madam. Yeah, this is a site. I think there were issues with delivery, and on that basis, it pushed back the supply in the trajectory in light of previous delays. But they maintain confident that with the revised trajectory that it will be delivered within the 5-year period.
So that's one part of a much larger scheme.
That's correct, yes. 3,520 dwellings, I believe. And that the contribution to land supply from that particular site would be 170 units in the 5-year period. I think we put some additional information in the rebuttal insofar as the site is subject to a development brief SPD to guide development, and development partner Urban and Civic owned land was selected in February 2018 and out on application with all reserved matters except access has a resolution to grant consent July 2020, and the associated legal agreement is being finalised. So again,
a year on from the resolution, still not concluded.
Still not concluded as far as I'm aware, madam.
Mr. Brown?
Yes, ma'am. Nobody underestimates the importance of Many Down to Basingstoke in terms of its delivery of housing and much needed infrastructure. The issue here is one of deliverability. It is demonstrably not deliverable as at the base date, nor is it deliverable now. An application went to committee. There was a resolution to grant. That was back in July 2020. You'll see in my SB2 document, which is a report to the Many Down Executive Committee in January 2021.
Just give me the page number reference.
Document SB2 to my evidence, ma'am. And that SB2 is a report to the Many Down Executive Committee in January 2021.
Yeah, I have that.
Okay. And then if you just flip to page 5 and paragraph 3.1.6.
Yep.
In that, it's the last sentence of that paragraph. The programme proposes finalisation of the 106 by the end of March 21. Well, we're another 6 months on from there and still no resolution. So at every turn, Many Down has indeed been delayed rather significantly. Now, the previous AMRs, the 2016 AMR for Basingstoke, had this site delivering 650 completions by the middle of 21. So the 2016 AMR said 650 completions by mid-21. The 2017 AMR had 420 completions by mid-21. So in short, this council have always been overly optimistic in their assumptions for Many Down, and it clearly was not deliverable as at the base date, and it's not deliverable now. So it is clear to me that on the basis of the requirement of the framework and the PPG, it's not deliverable, and all of those 170 dwellings fall out of the council supply figure because it is not deliverable, ma'am.
Mr. Magnuson?
I've got nothing further to add, madam.
Okay. Okay. Oakley Hall. Mr. Magnuson, any comments on Oakley Hall?
Just that subsequent to the 2020 AMR, planning permission was refused on the 30th of April 21 on detailed matters including site access. However, there were no in-principle reasons for the refusal, and the council considers that subject to amendments including access arrangements, the objections to the scheme are capable of being addressed through a resubmission. The applicant has in fact made a subsequent resubmission in May 2021, and you've got the application reference number there, and that's to run in parallel with a fast track appeal. And again, the council remain of the view that the site is deliverable within a 5-year period.
So, Ms. Maxon, I think, ma'am, did you say Oakley Hall?
That was the next on the. This
Yeah,
is the
I think
page
Mr. Magnuson, that's not Oakley
So,
Hall.
sorry, is that's Oakley Hall. Sorry.
Yeah, at the minute I've got
That was a
outline
different site.
application received resolution to grant in November 2020.
Yes, that reference, Miss Magnuson, I'm sure you'll agree, was to a different site, Mum.
Yeah, I agree with that. Sorry. This is the Oakley Hall site, isn't it?
It is, yes.
Yeah. So that site is allocated for approximately 30 units under policy S3 of the adopted local plan. An outline application for up to 33 units was submitted on behalf of the Fogarty Group Limited and Cave Construction in December 2018. Was due to be determined in late 2020. When in their response to the council in July 20, the agent of the developer declined to provide an update on their previous AMR delivery schedule for the 30 dwellings. The agent noted that the outline application is still awaiting determination, and solent nitrates matter clearly reaching a conclusion on that process will assist in bringing the sites forward. Furthermore, the client continues to promote the site as a location for a continuing care retirement community, and an application has been submitted in that regard. So
That's instead of the 30 dwellings, is it?
that's how I understand it, yes. But I think that the way the council see this is that is a firm commitment from the developer to bring forward that site for development within the plan period.
Okay.
And again, I should also add that the basis for the inclusion of the site within the AMR schedule for 30 units is the actual quantum of development as outlined in the neighbourhood plan allocation.
Yeah, I see that. In terms of the south of Two Gates, I'm aware that that site is to be considered at a forthcoming appeal. So I don't think there's necessarily much more for me to say on that matter. Is there anything either of you wanted to add? I see Mr. Brown's got his hand up, and I'll just ask Mr. Magnuson first, if I may, in terms of the council's position.
No, not beyond the text within the rebuttal statement itself, madam, at this stage.
Mr. Brown?
Thank you, Mum. I just wanted to come back and take the opportunity to respond on Oakley Hall, if that's okay. On Oakley Hall, I think the case is made at Mr. Magnuson's paragraph 2.31. So in addition to my evidence, just have regard to what is said at paragraph 2.31, and it sets out the agent's response on behalf of the developer to the AMR. It makes it clear in italics. Please note that our client continues to promote this site as a location for a continuing care retirement community, and an application is being submitted in that regard. So that is a suggestion of 30. It isn't deliverable, and that's not what they're going to build out, and there's no permission for the bigger scheme as things stand.
But that doesn't negate the intention for that site to deliver some units that would contribute to the housing supply.
I think that's very fair, and Mr. Magnuson said in the plan period, and I agree it may come forward in the plan period, but there's no cogent evidence of delivery at the base state for either scheme on that site, Mark.
But there's a valid application in for making sure I've got the right one. It says at 2.33, the application for a retirement village remains under consideration. So that is before the council.
Absolutely.
Okay. Sorry, was there anything else on Two Gates before from yourself, Mr. Brown?
On Two Gates, if I can take the opportunity to respond on Two Gates now, that'd be helpful. Thank you very much. Just on Two Gates, I picked up on Mr. Magnuson's paragraphs 2.37 and 2.39. And again, this is a submission on behalf of the developer in italics, where references should it secure permission this year. And it goes on to say, this is of course subject to it securing its detailed consent in a timely fashion. And you've heard what the position is in terms of the appeal and duplicate application. I don't need to expand upon it there in terms of whether it's deliverable or not. I've made my position clear. Thank you.
Okay. on, is it Falconer or Falconer Road? Mr. Magnuson, it's 2.42 of your rebuttal.
Falconer Road, yeah. That's 12 units. Outline permission was granted for that site in January 2021. Pre-application discussions are ongoing with the agents with regard to detailed proposals for the site, which in the opinion of the council demonstrates clear progress in respect of deliverability within the 5-year period.
Mr. Brown?
Thanks, Ma'am. I appreciate it's a small site, but in short, outline permission was granted in January 21, well after the base date. There's still no reserve matters application. And contrary to Mr. Magnuson's assertion at his paragraph 2.45, pre-application discussions do not in any way, shape or form demonstrate deliverability. There's no RM, and in essence, one applies the approach in Sonning Common, which is paragraph 21 of Sonning Common, and that's CD 5.12. Thank you.
Sorry, CD 7.12.
CD 5.12.
Sorry.
That's okay.
Thank you. Towns and fields we've talked about. There were two in the list at Coppice Road, Kingsclear, and Stokings Road, Kingsclear. Are there any comments to make about those two?
I'll happily jump in there. Those two sites were initially relied upon by the council in their AMR as being deliverable, but through discussions with the appellant on the earlier Station Road Oakley appeal, it was agreed that the council were no longer going to rely upon those, and hence you'll see them in table 2A2 of the Housing Land Supply SOCG, where the council's current position is 0 of delivery from those two sites, and they're not included in their numbers.
Right. Okay. Thank you for that clarification.
If I can just concur with Mr. Brown, they have been taken into consideration in respect of the statement of common ground and the respective 5-year land supply positions.
So what was the reason they were in the list of disputed sites when they were both, there were zeros against both your assessment and the appellant's assessment?
Could you just tell me which document you're referring to?
The statement of common ground.
Yeah.
The housing statement of common ground says that these table 2 lists the disputed sites, but in relation to 9 and 10, there are zeros in both columns. I know. Yeah, there are obviously 24 dwellings involved. But what was the purpose of them being in that list of disputed sites? What was the point I'm obviously missing? So why they were there?
I don't see there was any particular point in the sites being there. Mr. Brown may contradict me there. He may find an explanation, but I thought we'd bottomed out that they were not deliverable and they've been factored into the council's calculations. But I could be wrong. Mr. Brown, you may have something to add.
No, you're absolutely correct, and Ma'am, you're not missing anything at all. They were simply included as a cross-check, so there was no dispute then working back from the AMR figures, because there are occasions, because of the evidence base, you've got the AMR, and if sites are just dropped out without any reference to them, it's difficult to correlate the numbers. So that's all it was, just for that purpose. And it's in table A2, it's the second column of that, which is the council's position. So there's no issue between us.
Sure, I think it was just for sake of transparency.
Okay, I just wanted to double check I hadn't missed the point that you were wanting me to take account of. So in terms of the discussion on weight, and I appreciate that whether we include or exclude any of those sites, dials it either up or down, whichever way you conclude. And I don't necessarily want to pursue that point any further, but with only half a year's supply difference between the two positions, I was seeking really to understand why that was called a significant shortfall. as opposed to Mr. Miller's description of it as a modest shortfall. Are there any comments from either of you on that point?
Ma'am, I'll quite happily explain my position. I've made it clear that on my analysis, the shortfall on my position is significant, and I dispute the council's assessment that it's a modest shortfall on their figures. My view is, even on their figures, it's a significant shortfall. Now, without going into full detail for you, because I appreciate this is just a round table session to respond to your questions, but it's a matter of planning judgment. One has to look at the context within which we are considering 5-year land supply. So the starting position is the 2019 AMR, that is CD 3.10. And you need table 5.3 from that. So the council confirmed a shortfall on the 5-year position in 2019. Exactly the same references in the 2020 AMR, and that's CD 3.11. Again, table 5.3 confirmed a shortfall. One then picks up the Station Road appeal decision, which is CD 5.1. And in there are 3 key paragraphs on this issue. Paragraphs 89, 90, and 91. And in short, that references the anticipated continuation of the lack of a 5-year supply. So this is not just a snapshot in time. It's not just from the 2020 to 25 base date. This is a problem. It was a problem in 2019. And crucially and importantly, if you pick up figure 5.3 in the 2020 AMR, so figure 5.3 in CD 3.11, that has the council's trajectory for each monitoring year. And if one applies the current standard method requirement for each 5-year period from here and in, the council does not show a 5-year supply of deliverable housing land until 2029. They don't do it. For the next four periods, there's no 5-year land supply at all. That for me is an acute issue, and it demonstrates why one needs to release sites now to meet the current shortfall and the ongoing shortfall. And an easy reference, if we can just take a couple of minutes on this, is, Mum, could you pick up SB3, which was a document to my proof?
What page number?
It's a document in itself. It's SB3.
Yep.
And it's
2nd of September 21, Planning and Housing Committee.
Very rapid, yes, much quicker than I am virtually, I tell you. Yes, it's that, and it's page 8 of that. And it's paragraph 2.10. There's a big table in blue and red. Mm-hmm. And there's a paragraph 2.10 under that. If I just read out the first sentence. The borough's housing trajectory shows a shortfall in housing delivery within the next 5 years, and again following the current adopted plan period of 2029. And then 2.11 requires housing in rural locations, especially in relation to the 5-year land supply. So in short, this is not a flash in the pan. This is a persistent and continued issue for Basingstoke and Dean. They are not going to have a 5-year land supply of housing land for the foreseeable future without the release of sites now. So I do not accept for 1 second the shortfall is modest in the context within which we are considering the land supply position. It is a significant shortfall.
I think the point I was making was on the mathematics side of things. I appreciate in the overall context that's one thing for me to consider, but I really was looking at picking up the point Mr. Miller made about, in his view, the 4.83 as he calculated it was a modest shortfall from the 5-year position that they're required to have. Mr. Magnuson, did you have any comment to come back after what Mr. Brown had said?
Only so far as Mr. Brown was going back some period in time there and looking at historical delivery. Yeah. I mean, the 5-year housing land supply is a snapshot. And the way the council see things are that they have a 4.83-year supply, housing land supply. And I certainly do not consider that to be a significant shortfall, madam.
Okay. That picks up the questions that I had on housing land supply. So thank you very much to you both for that. If there is nothing else that you wish to outline or highlight from that, I'll move to back to Ms. Burke and Mr. Boyle in relation to working out who's going to take part in the discussion on the 106 agreement. Thank you, Mr. Magson. Mr. Brown.
Thank you.
Mr. Boyle, who did you wish to bring in relation to discussions?
Madam, can you see on the list, there's a gentleman by the name of Tom Alder.
I see him, yes.
The appellant solicitor who's been dealing with 106 obligation. And I don't see her on the list, but yes, Miss Wright is there in terms of the discussions. Obviously, Mr. Alder is there to assist you with the terms of the agreement itself.
I wanted to have just a general discussion in terms of whether or not the council were content for the in relation to the triggers for the various different requirements. Obviously, in the statements of common ground at table 8, those tables were not completed, and I just wanted to revisit that with you. Perhaps the council can speak to that in relation to whether the triggers are satisfactory from your perspective.
Madam, may I just bring in, yes, Gemma Cox, who is the planning officer, and if needed, we may also need to bring in our legal officer, Emma Bethnal, but for now, if I can just hand over to Ms. Cox, please.
Welcome, Ms. Cox.
Thank you. Yes, just to say the unilateral undertaking that was submitted to yourself by the appellants has been reviewed.
I'm sorry, I can't hear you very well.
Can you hear me now?
Yeah, that's better.
Yeah, the unilateral undertaking that was submitted by the appellants to yourselves has been reviewed by council and council officers, and in conjunction with the legal team, we are in agreement with that document and all of the associated triggers.
Okay. There were a couple of points that I just wanted to pick up in terms of its content, and that was mainly from the point of view of some clarification. I know, are you content for me to go on to pick those points up with you now?
Yeah.
Throughout the document, there's numerous references to the owner, but in the interpretation, the definitions, that's articulated slightly differently as the owner's property. I think it would be helpful if the owner, if it's going to be referred to consistently through the document, is also in that list and defined correctly.
Yeah, I can see that. Can I just bring in Emma Bethel on that particular point?
By all means. Miss Bethel?
Apologies. Can you hear me?
I can, yes. I can't see you, but I can hear you.
Okay, apologies. I'm not sure what's going on with the camera. I'll see if I can get it to work. That's fine. I can see, I'm just looking at the document now to check I'm looking in the right place, but I can see it, for example, at 0.2, it refers to the owner's property. So I'm happy to arrange for that to be clarified if that would assist, and we can add in a suitable definition if that would be suitable.
On page 8, there's a need just to update the Secretary of State title. I know it's happened since the document was put together, but just for the interest of clarity and consistency. On page 14, paragraph 18.2. The application reference number is referred to, but it's not given elsewhere in the document. So I wonder whether or not, just for the sake of completeness, that should be there.
Madam, if I may, the application reference number is on the very first page of the document, on the cover page, but I'm equally happy to add it in elsewhere if that would assist.
Yes, you're absolutely right. That is correct. It was just, I was just trying to make sure I'd picked up the detail. And on page 20 at paragraph 1.3, it refers to a table at paragraph 1.1, but there doesn't appear to be a table at 1.1.
Sorry, madam, I'm just finding the right page.
It's under affordable housing at paragraph 1.3 on page 20.
Ma'am, if I can interject on behalf of the appellant,
Yep.
I think that's my apologies, that's a typo left over from an earlier incarnation of the
Right.
draft, so we'll get rid of that.
Yeah. It's just I couldn't follow where you were directing me to. So.
No, apologies.
And at 1.12 on page 22, it just says an otherwise agreed in writing. It doesn't say by whom or between whom.
Again, very happy to add that clarification, Mum.
I'm sure that's easily
Thank
corrected.
you. My next point was at 2.4, but that picks up where the owner is referred to. And my next point is on page 43. And there's just an inconsistency in terms of the heading 6 and paragraph 6.1, where it talks about and or open space, and it's just or in the title.
Yeah, again, very happy to amend that, madam.
And forgive me, just going back one page on 42. You've used the term a reasonable service charge, but I just ask you who defines what reasonable is.
Sorry, where are we, Inspector?
Page 42 at bullet point I at the top of the page.
I think the answer to that question, ma'am, is that it's the appellant's or the owner's obligation to ensure that a reasonable service charge is set. If bear in mind the owner's got to submit a management scheme to the council. As part of that, we have to demonstrate that the service charge is reasonable. If the council don't feel it is reasonable, they then have the chance to counter that to the point to which the scheme is submitted to them for approval.
Okay. And I think that was the points that I had in terms of detail. It was just that really the other discussion was on the triggers, which the council have clarified are acceptable to them. I think the only one that was giving me a little bit of nervousness was where it was linked into prior to the occupation of a penultimate unit, and that was then the delivery of the allotments. I thought that was quite late on in the development, and wondered why it was so late in the build program. Any comment, Ms. Cox?
Sorry, I'm just trying to find the relevant section here. I think all I can really say is that it's been reviewed by the relevant officers within our open space team, and that they haven't raised any issues with the proposed trigger there. So we haven't raised any objections to that.
Okay, on the basis that you're content with the triggers, then yeah, that's as things are. Were there any other queries that the council wish to pick up on in terms of obviously I'm aware that the document hasn't been with us for a huge amount of time, but you're content that you've had an opportunity to go through the fine detail?
Yes, thank you.
And whilst I appreciate we're still to go through landscape evidence tomorrow, but assuming that that doesn't pick up any further points in relation to the 106 agreement, what's the intended timing of an executed version?
Madam, can I help? Mr. Alder can jump in, but my instructions are that it needs to go to Singapore and a fortnight after the close of the inquiry is sought. So what we'd propose to do, we take on board the drafting points identified and issue to you before the close of the inquiry this week the final draft that will be signed, and then it will be sent for execution and returned within a fortnight.
Well, I mean, normal expectation would be we would be concluding things before the end of the inquiry. But if that is physically not possible, if you can send that revised draft through, that would be helpful. And I'll give some thoughts as to whether or not I'm in agreement to that 2 weeks.
Yes, I mean the document that you'll get at the end of the inquiry will be the document to be signed. It just won't have been executed as the inquiry closes.
Okay, I note that point.
Thank you.
So in terms of where we go to next, that will be opening tomorrow morning with Mr. Cook's evidence on landscape matters at 9:30. Before I close today's session, are there any points from either side that you wish me to be aware of, or any points of procedure you want to raise? No. Okay, thank you very much. In that case, proceedings for today are adjourned, and we'll open again tomorrow morning at 9:30.
Thank
Many
you.
thanks.